Child support is calculated either by agreement or based on a formula. So there's a chart in the Texas Family Code that you can look up, and it basically provides that the net available resources of the paying parent's income is multiplied by a percentage. For one child, it's 20%, two children, it's 25%, three children, 30%, four children, 35%. And then if you have children with another person, then it's the formula then adjusts, and each different, if you have two children subject to this lawsuit and then two children with this other person, then the formula changes. So you just need to look at the chart. The chart will tell you, and it's based strictly off that, or it's based by agreement. You can agree to any amount, either more than what's called the guidelines. So those are called the guidelines with the formula. You can agree to more than guideline, or you can agree to less than guideline. And depending on how much custody or different things, if there's private school that somebody's paying for, a court typically will not and does not order private school to be paid for. So when private school is being paid for, we basically are in a great big negotiation. All child support is negotiated. Even if you were to go through the Attorney General to determine the child support amount, the Attorney General is going to have a negotiation conference with you, or they're called a mediation or settlement conference ahead of time before they even go into court. Almost every court in the state of Texas requires mediation, which is a scenario where you go in to agree and they're trying to get an agreement about child support. But if a court does have to decide it, then typically they're going to look at the income of the paying parent and apply that formula strictly. But a lot of times what we will do informally is we'll look at the amount that both parents make, and we'll take a look at that and determine, well, how much does it need to be? And a lot of times child support makes sense, even if it's, I've had clients that by all rights, the other side should be paying them money based on the strict formulas. But I've had clients that will decide to pay child support to the other side. Why? Because they're buying something for their children for their money. They're buying the best parent that other parent can be for their kids. And you need to look at this and say, well, okay, what makes sense? What's good for the kids? What's really going to work out well? You don't want to have abundance on one side and lack on the other, because the children are going to judge both of you for that. How come you don't help my other parent? And how come you let my other parent take advantage of you? It's kind of a no-win situation. But when you have good balance on both sides and the kids are able to be taken care of, that leads to a good co-parenting relationship. A good co-parenting relationship is the best blessing that you can ever give to your kids. Put aside the fact that you can't live together as husband and wife anymore, and instead realize you're still dad and they're still mom, and you get along and co-parent with them as well as you possibly can, and figure out something that's healthy. And don't try and take financial advantage of the other side. And if you're facing that and you want to get something that's good and healthy and get really good results for you, then go to softdivorce.com. We'll help you get through it in a healthy way, because divorce doesn't have to be so hard. So if you're supposed to be receiving child support and you're not receiving child support, then you can get an attorney, or you can go through the Attorney General of the state of Texas and file what's called a motion to enforce, and it's via contempt. If someone is not paying child support and it's been ordered, then their failure to pay that can subject them to jail time. Child support is the most collectible debt in the state of Texas. It never goes away, it accumulates interest over time. So you can enforce that. Now, there's statutory time limits. You need to enforce that within the first couple of years after the child's 18th birthday. If you go, 4 years, I believe it is, then you waive it, and they can't enforce it by contempt anymore, and it loses its teeth. But if you need to file that, you can do that. Now, if you go through the Attorney General does not represent you. The Attorney General represents the state of Texas, and you are just two people that happen to come in, and child support's owed. And they get their funding based on showing their statistics of, here's how many billions of dollars we collected in child support. So they just want to get the child support paid. But they can turn on you. They're not necessarily on your side, and they have so many cases, they're not going to be able to spend a lot of time, put a lot of time into that. There's some fine attorneys at the Attorney General. There's some that, they're balancing out a lot of different things. If you can hire a private attorney, it's usually better for you to hire a private attorney. The Attorney General, though, is free. You got to determine what the best way to go is. But you should definitely talk to a private attorney at least before you do that, because what happens when you try and enforce a child support arrearage, meaning they owe you money, is they're going to counter it with a child support modification, a SAPS, or suit affecting parent-child relationship. They're going to fight and try and take custody away. They're going to try and get the amount of child support reduced. So you got to make sure that you're not putting yourself into a roller coaster that you can't get off of, that you're like, I just wanted to get this. I just wanted to get my child support collected. And now you realize that you're spending $50,000 fighting a child custody case and you're about to lose your kid or who knows what. So you always should talk to a private attorney before you attempt to do any kind of collection of child support. But if you're owed child support, and for example, if you wait till the child's 18, the obligation is still there, and you can collect it, file it, when they on their when they're 17 or 18th birthday, file it then, collect it then, and boom, you got your windfall that you've been waiting for, and it's bearing 6% interest. The other thing is that if your child is disabled, you can get lifetime child support, but you have to do that and request that before the child is 18. So if you're facing any of these situations, you're welcome to go to softdivorce.com, and we're at the Palmer Law Group. We're happy to help you. Can you change the amount of child support you're getting? Yes, you can. If the amount is going to change by more than $100, or if it's been more than 3 years since your last order, you can request an automatic review, and you're entitled to it. You're entitled to the review. Now, if you do that, you do risk that they're going to try and come back and adjust the amount and argue, and you might be back to square one and arguing. The other side may enjoy litigation and like fighting with you. So you got to be careful that you're not getting onto a roller coaster that you can't get off of. But the child support amount can be changed. You can also, if you lose your job or your income drops way down, you get disabled, there's some kind of substantial change of circumstances, the amount that you pay can be reduced. But if you're facing any of those situations, you really need to talk to an attorney to determine, is this something that's worth it or not? Is it going to be beneficial? Am I opening a can of worms that, once the cat's out of the bag, I ain't getting it back in that bag? So talk to a private attorney before you do that, even if you are going to go through the Attorney General, which the Attorney General services are free, but it's kind of one of those things, you get what you pay for. They're a government entity. They don't have a lot of time. They don't have a lot of resources. And they can take a long time. I've seen it to where it takes 6 or 9 months before they even file the case. And the child support was supposed to go up $2,000 a month. It doesn't increase until the case was filed. Well, that's $18,000 worth of child support you didn't get, and it would have made $5,000 or $10,000 for you to hire a private attorney. So you get what you pay for. You should definitely consult with a private attorney before you decide to go with the Attorney General if you're going to do any kind of change to the child support amount that's already ordered. And we're happy to help you with that. You can go to softdivorce.com and schedule a consultation with us. In Texas, child support typically ends at age 18. You can get lifetime child support for a disabled child, but typically it's 18 and graduated from high school. If they're still in high school and pursuing actively a diploma in high school, it can go, age 19, 20, whatever, as long as they're actively pursuing that. You have to have requested that for lifetime child support for a disabled child. You have to request that prior to the 18th birthday. You have to have your pleading on file before that. But typically it's age 18 and graduated from high school, the latter of. So if you're looking at any kind of change to child support, you need to get child support in place. Anything having to do with child support, child custody, visit us at softdivorce.com. We're happy to help you.